This is a lecture for my professional responsibility class. We're talking about conflicts of interest under Model Rule 1.7 and specifically about conflicts that arise in litigation settings. And so when we have an adversarial process. Comments 23 to 25 under Model Rule 1.7 to focus on specific, kind of fleshing out specifics about the conflict of interest issues that arise for litigators or lawyers representing parties in litigation. There's a few reasons or ways to think about the conflicts of interest that can come up. First is, let's say you have substantial discrepancy in the party's testimony. And so here we're envisioning that you might be representing co-defendants in a civil or criminal litigation or co-plaintiffs in civil litigation. And if they're going to testify or have an account of what's happening or even submit testimony through affidavits, if there's discrepancies, then you have a conflict of interest. Then this creates a problem, and you have a potential conflict, or you have a conflict because of the potential for this. But this is what the way that the conflict may manifest. Also, there could be incompatibility in positions in relation to an opposing party. So, for example, one of the litigants that you represent as a co-plaintiff or co-defendant could kind of like the other side or not want to punish them, and they just want to be made whole or be compensated or want an apology or something like that. And the other person in the group that you're representing might want kind of to punish them or to take them down or exact revenge or something, or to expose and embarrass them. And the fact that there are substantially different possibilities of settlement of the claims or liabilities in question. And so this is very common, very foreseeable that parties are going to disagree about whether to settle and how much to settle for, how to allocate this settlement, how much of the settlement should just be a payout and how much of it should be an agreement to sort of undertake certain behaviors or actions, and so forth. Now, these conflicts can arise in criminal cases as well as civil. Criminal co-defendants, when we're talking about criminal co-defendants, the potential for conflict of interest in representing multiple defendants in a criminal case is so grave that ordinarily a lawyer should decline to represent more than one co-defendant. And I want to talk about this for just a moment for my students to think about the things that can go wrong. So we kind of have our classic sort of like Law and Order episode scenario where a prosecutor may offer each suspect or co-defendant, let's say, or each accused, a plea bargain to testify against the other, or may offer some of them a plea bargain to testify against the ringleader, let's say, of the conspiracy, and so forth. So this creates a clear issue for the lawyer right off the bat. That how are you going to tell someone to turn down an offer that's really generous or would be advantageous for them? And just because they would be testifying against someone else that's your client. And so this can create all sorts of problems. It's foreseeable that this will happen, and you should probably avoid it. Now, let's say, for example, that there's no deals, right? The prosecution has said, we're not offering plea bargains, or everybody has said, we're turning down plea bargains, and so forth. Even so, if they are tried together, when the parties are tried together, there's a natural tendency for people to minimize their role in whatever went wrong, or the criminal undertaking or the conspiracy or something. Sometimes they will expressly highlight or shift blame to one of the other members. So even if they haven't been offered a deal to testify, they could say something like, look, this wasn't really my idea. I just kind of went along with it, or I was pressured into it, or something like that, trying to make themselves seem not so blameworthy to the jury or to the fact finder if it's a bench trial. And but the problem is, if you have co-defendants in a criminal trial, this is kind of a zero-sum game, and when it comes to blame. So if one of them makes it seems to seem less blameworthy, it makes the other conspirators or parties seem more blameworthy, like maybe this was all their idea. And by the way, prosecutors love this, right? You're doing, they love trying people together in a joint combined trial, because they do the prosecution's work for them by making each other seem bad, and and people aren't as good at arguing for their own innocence as they might think. And so what we could have a problem with that too, is that even merely the fact that they are downplaying their role in the crime or their blameworthiness in the crime can make the other conspirators or co-defendants seem more blameworthy, or more at fault, or more responsible for what happened. And so we have that type of conflict as well. And again, there's other issues like that we could have that come up with how the trial is going to be done and who will be called as witnesses and so forth. And of course, the stakes are very high, right? We're talking about putting people in prison, kind of keeping people in a cage for years and years of their lives, or in some cases they may be facing execution. But criminal conviction, going to jail, it can really is going to have far-reaching consequences for your whole life. It's very hard to ever fully recover from that, as you know. And so this is so grave, we wish lawyers wouldn't do it. Now, let me explain why this happens anyways, and why sometimes lawyers do agree to do criminal cases. And this is a difficult situation. So first of all, you could have people that are arrested together and they're co-defendants, co-accused, and they don't have a lawyer. And so you're a criminal defense lawyer and the whole group wants you to represent them. And I have seen this happen where the lawyer will say, look, I will do your arraignment and bail hearing, but I can only do one person's trial, or I'm not doing all of your trials, or something like that. And at least they have representation during that pre-trial phase, during those preliminary hearings and arraignments, and when we're setting bail and so forth. And the conflicts the potential conflicts are minimal at each incremental step. So if we're just talking about showing up for an arraignment where we read the charges and make sure that this is the person and we hear their pleading, or something like that, maybe a lawyer could do that, and that you will have to get informed consent confirmed in writing from each defendant. But that's not as serious as trying to do the whole criminal trial that's going to go to verdict for the co-defendants. And the alternative, of course, is saying no. And the problem with declining representation is that we have a big problem with the representation of criminal defendants in our country. And so we have a lot of people, I've seen reports that could be as many as 75% or 80% in some jurisdictions would qualify for indigent defense and really can't afford to hire a lawyer. And then there's a whole group that it's financially devastating for them to hire their own lawyer. And so if you think about the correlation between income, or the being low income or living in poverty, and the likelihood that you'll be accused of a crime or find yourself charged with a crime, it makes it hard that lawyers are expensive and that we're going to make everybody hire their own lawyer. And so you may be thinking, well, what's the problem? Won't they qualify for a public defender or something like that? But think about the fact that the public defender's office is going to have a conflict of interest in representing this group together. So we haven't really gotten to an imputation yet in conflicts, but there's a really good chance that the conflict, if one of the lawyers has a conflict, they all have a conflict, which means even if you have a public defender's office, some of those people might get referred out to the people that are offering to be taken off of picked off of a list to do the representation. In other words, there's access to justice concerns for those who are accused of crimes in our country, and the conflicts can end up serving to just further limit the pool of lawyers who are available to represent criminal defendants in one locale. and that's a problem. And now, if you're in a major urban center like Houston or New York or Los Angeles or Chicago, it may seem like there's an endless supply of lawyers. But if you're in a smaller city like Hartford, Connecticut, or even a small town like Mesquite, Texas, or someplace like that, the number of criminal defense lawyers available and is limited, and then we are going to reduce that even further with conflicts, and this is just a difficult situation for our criminal defendants. Now, with civil co-defendants, there's still a problem here, but we're not as concerned from a policy standpoint and a justice standpoint as we are with those accused of committing crimes. And so, on the other hand, the comments say, common representation of persons having similar interests in civil litigation is proper if the requirements of paragraph B are met. And remember, paragraph B is the lawyer believes that he or she could provide competent, diligent representation in spite of the conflict, that you will be able to be unbiased and represent everyone adequately. And it's not otherwise prohibited by law. It's not the sitcom scenario where you're trying to be the plaintiff's lawyer and defense lawyer in the same litigation, and each client is willing to give informed consent. When you explain the conflict to them, they consent anyways, and they'll put that in writing. Now, much of the law involving conflicts of interest in criminal cases it really interprets the Sixth Amendment right to effective assistance of counsel. In other words, our ineffective assistance of counsel appeals based on the Sixth Amendment generate most of our U.S. Supreme Court cases about conflicts of interest, at least in criminal cases. And so now there's something to keep in mind here. We have a key case of Mickens v. Taylor from 2002, and that says when a trial court fails to address a potential conflict about which it reasonably should have known, the defendant must establish that the conflict adversely affected his lawyer's performance. Keep in mind that ineffective assistance of counsel cases is going to follow the two-pronged test from Strickland, which means, first of all, you have to show that the lawyer was objectively far below the standards of conduct expected in the legal profession. The Supreme Court has said you're not entitled to a great lawyer, just a lawyer. In other words, if your lawyer's mediocre, that's not ineffective assistance. So the classic scenario is the lawyer who just forgets to show up for your trial, the lawyer who doesn't object to anything, who sleeps through the litigation or shows up intoxicated on the day of trial, and things like that were the original idea of ineffective assistance. But now, even if you can prove ineffective assistance of counsel, there's a second prong, which is you then have to show that the outcome probably would have been different if you'd had a different lawyer. And that's very hard to do, right? Remember that if you're being charged at all, the prosecutor has probable cause, and then they have the whole trial, the opportunity to put on a case and so forth. So what's going to be happening on appeal under a Strickland case, under an ineffective assistance of counsel complaint, is you have to show that your lawyer was ineffective, and showing a conflict of interest, a clear conflict of interest, will usually meet the first prong. And I want to make sure you understand that, that the lawyer having a conflict of interest will often satisfy the first prong of an ineffective assistance of counsel complaint. In other words, or appeal. In other words, that will count as ineffective assistance. The problem is we're not going to reverse the conviction if the evidence is so overwhelming that the court thinks you would have been convicted even if you'd had a lawyer that didn't have the conflict. And so criminal defendants appealing on ineffective assistance of counsel are likely to fail on the second prong, even if they get, of the group that can meet the first prong and show that their lawyer actually was ineffective or did violate the ethical rules or something like that. Of that group, most of them are going to fail on the second prong because when the appellate courts read the trial record, there's going to be often plenty of evidence to support the conviction. We have a couple older cases. In Wheat versus United States, 1988, the Supreme Court held that a district court has the discretion to disqualify defense counsel even if the defendant waives a conflict. And so do keep in mind that a judge can, on her own motion, disqualify you as a lawyer if you're trying to represent co-defendants, even if those co-defendants agree. So it may be that the group says, no, we can't all afford our own lawyer. We want to share one. And also, we think it's better to kind of keep our secrets confined to one person we trust. And so maybe they are all willing to put it in writing that they really will waive any conflicts of interest. The judge can still say, I don't care. I don't like this scenario. I don't want a reversal later on because of ineffective assistance because of this conflict. And so each of you has to have your own lawyer and can essentially has the authority to fire the lawyer from representing people. We have this old case that's from long before Gideon versus Wainwright, Glasser v. United States in 1942, which said that the federal courts may not force a defendant to accept an appointment of counsel who is representing another defendant in the same proceeding. So remember, in the early 20th century, the federal courts first began this idea of everybody should have a right to a lawyer, that the Sixth Amendment required that the government provide a lawyer to people that couldn't afford it. Gideon versus Wainwright, many years later, applied that to the states and said that defendants in state cases also have a right to a government-funded lawyer if they are indigent and can't afford one. But this is before that time, and we're only in federal court, but even in federal court at the time, there were a lot of judges who didn't like this and who had no sympathy for criminal defendants and didn't like it that they got a free lawyer. And so what they would do is just stick people in a group and make them all use the same lawyer, even though that lawyer had conflicts. And in 1942, the Supreme Court, to their credit, said you can't do that. Ordinarily, a lawyer may take inconsistent legal positions in different tribunals at different times on behalf of different clients. The mere fact that advocating a legal position on behalf of one client might cause precedent adverse to the interests of a client represented by the lawyer in an unrelated matter does not create a conflict of interest. In other words, if you want to advocate for the reliability of certain types of, let's say, testing, DNA testing or something like that in one type of case, and or the reliability of certain types of evidence in one type of case, and in another case later on you're going to question that very type of evidence, that's okay. As a lawyer, you do not have to be completely consistent in every position you take case to case, and instead you're going to put on the best case you can for your client. And it's okay if what you're arguing in one case, another client would not have wanted you to argue. And that's not necessarily a problem. Or to put it another way, if you are representing Greenacre in litigation and you're taking a position that Goldenacre wouldn't like, in a sense, that does not automatically create a conflict of interest. On the other hand, a conflict of interest exists, however, if there's a significant risk that a lawyer's action on behalf of one client will materially limit the lawyer's effectiveness in representing another client in a different case. And so, for example, we're talking about a decision favoring one client will create a precedent likely to seriously weaken the position taken on behalf of another client. And so the fact that you're representing, let's say, Greenacre and taking a position that Goldenacre won't like. And so let's say, for example, we're going to take this out of the criminal context for a moment and say you're representing companies, and so you're representing Greenacre Corporation. And as part of this, you are challenging the validity of a federal regulation that applies to this industry that Greenacre is alleged to have violated. So instead of saying they didn't violate it, you're saying the whole regulation is legally invalid for one of the reasons under administrative law. And Now, it may be that Golden Acre actually likes, who you also represent, likes that regulation because it's easy for them to comply with and it creates entry barriers for market competitors and so forth. That's not a conflict of interest. What is a conflict of interest is if two of the clients you represent essentially are in a zero-sum game on one particular issue. In other words, winning an issue for one client directly impairs the case or kind of forfeits the case or is a setback to the case in which you are representing another client. Also keep in mind this can be successful advocacy of a client's legal position in one case that could be detrimental to the interests of a different client in another case. So we can call this positional or issue conflicts. And here's a kind of an interesting example from Delaware in the early 2000s, in 2002. There was a lawyer who did death penalty cases, a criminal defense lawyer who did death penalty cases. And at the time, he had two cases, and in one case, one of his cases, he was doing these at the same time, the jury had recommended the death penalty, and the judge had said, no, I don't think so, and instead given the person a life sentence, and the criminal defendant. In the other case, the jury had recommended not against the death penalty, and the judge had imposed the death penalty anyways. The jury had not imposed it. And so the lawyer in one case was arguing that that the trial court in the second one was obligated to give great weight to the jury's recommendation against the death penalty, saying a judge shouldn't be able to impose a death penalty if the jury only wanted to give life in prison, right, or stopped short of the death penalty. And in the other case, it was arguing that the judge gave too much weight to the jury's recommendation in favoring the death penalty and should have made an independent decision. In other words, if the jury wants the death penalty, the judge should still be able to ignore that. Well, I hope you can see that if he wins for one, his other client is going to get the death penalty. That's a pretty serious high stakes conflict. And that's exactly the type of thing that the ABA is talking about. And the Delaware court said the same lawyer should not have been arguing both of these cases, because if you win one, you're hurting your other client, like sort of in the ultimate sense. Okay, some of you may have been wondering, what about class action lawsuits? How do you deal with a conflict with a large class with thousands or tens of thousands of people? And the answer is unnamed members of the class don't count as clients for purposes of conflicts of interest analysis. When a lawyer represents or seeks to represent a class of plaintiffs or defendants in a class action lawsuit, unnamed members of the class are ordinarily not considered to be clients of the lawyer for purposes of applying paragraphs A1 of the rule, which is the conflicts of interest rule under 1.7. So the lawyer typically does not need to get the consent of such a person before representing a client suing the person in unrelated matters. Similarly, a lawyer seeking to represent an opponent in a class action does not typically need the consent of an unnamed member of the class whom the lawyer represents in an unrelated matter. In other words, if you are representing someone and they're bringing a class action, representing a class, and it doesn't matter if somebody that you are otherwise suing on behalf of another client in an unrelated matter happens to be a member of that class. Okay, and that concludes this short lecture.